you, Mr. Chairman. Mr. Hoffman, your boss, Chairman Simons, was here last week, and I think it's safe to say I expressed my frustration of what I'm concerned is a pattern of enforcement or lack thereof at the FTC. And I said then, I reiterate now, that I'm increasingly concerned about your agency's ability to do its job. I'm concerned about some of the structural issues that the chairman has alluded to. I'm concerned about the pattern that I see. I'm concerned about the agency's ability to protect the public interest, to protect consumers' interests, and to protect competition and make sure that we're getting good, healthy competition that actually spurs innovation and again protects consumers. And so to that end, I am sending a letter to the FTC asking for the full report, the 2012 FTC report on Google's anti-competitive business practices. As you remember, I'm sure, the FTC launched an investigation into the anti-competitive practices by Google that culminated in a 160-page staff report in 2012. Half of that report was then inadvertently released during an open records request, but the FTC has never released the other half. And I think that the remaining pages are quite pertinent to the public interest for determining whether Google has been deceiving consumers for years and years. Google tells us that it simply returns the most relevant, useful results. But of course, 2 years ago, the European Union fined Google $2.7 billion for doing just the opposite. And the pages that we have from the report reveal that Google may have been involved, that the FTC was aware that Google was involved in this same sort of activity in the U.S. market. So I look forward to your agency's attention to that. Let me ask you about the recent report in the Wall Street Journal that several of my colleagues have already mentioned, the Project Voldemort report, I'm calling it, about Snap detailing the Facebook's aggressive tactics. The report says the newspaper story says that Snap was worried that Facebook executives were using Instagram to prevent Snap content from trending on that app. They were also worried that Facebook was encouraging popular account holders or influencers to not reference Snap on their own accounts on Instagram. Is this the kind of thing that the FTC is concerned about?
So, Senator, I can't comment on a particular pending investigation, but let me make a couple of broad points. One is information sources like the Project Voldemort, which, by the way, is a name that I greatly like, especially with kids who are huge fans of Harry Potter, as am I. But leaving that aside, that kind of information is the kind of information that we are constantly looking for and that helps us do good investigations. And that's one of the things that we have been doing in our technology task force, is going out to the market to try to build that kind of knowledge and expertise. Second, speaking broadly about types of practices as opposed to the practices of any particular company that we might or might not be investigating, I can say that we would look for systematic conduct by somebody with a large share, a dominant firm, that was aimed at disadvantaging rivals and potential rivals, particularly in ways that don't advance competition on the merits. And again, a great example of this is what we have alleged in the SureScripts case, which is currently pending in litigation. Or if you go back to the Microsoft case. The Microsoft case was a monopolization case that was comprised, and Chairman Lee talked about this in his opening statement, it was comprised of a series of forms of conduct which altogether created the monopolistic outcome. And that is the sort of thing, among others, that we would certainly look for.
Let me just ask you, at that level of generality, are you concerned about companies like Facebook acquiring competitors or would-be competitors and then using those competitors' platforms to strangle other competitors? So deliberately expanding into markets, as we're talking about here, I mean, potentially nascent competition, but expanding into markets where Facebook, for instance, does not have a foothold, expanding into those markets, gaining a foothold, and then using those new platforms to kill other platforms. I mean, that's the kind of thing you're concerned about. Is that fair to say?
That would be fair. Just to elaborate very briefly, I think you could think of two forms of conduct by a platform in that regard that could be anti-competitive. One is where the platform is doing something, any kind of conduct of which that would be a type, that would be aimed at forestalling a threat to the platform, the existing platform monopoly. And that was really what the Microsoft case was about, a threat ultimately to what Microsoft viewed as its platform that was posed by the downstream disintermediation of that platform and moving into a different direction. The second possibility is where the existing dominant firm in market A sees a potential to monopolize market B and moves into that market, engaging in anti-competitive conduct to acquire monopoly power there. I think that's a harder case to bring because there you're getting into more speculative territory about, as you said, a situation where the firm doesn't actually already compete in the market. But it's by no means impossible, and it's not theoretically untenable.
Thank you for that. Ms. Nakash, let me just ask you in the time that I have remaining, in your written testimony, you note that the percentage of IPOs for tech companies has decreased, and I just wanted to ask you to elaborate on that. I mean, are you concerned that newer companies feel that they may lack realistic ways to achieve the same size or success of earlier entrants like Facebook and Google that are now these very large incumbents?
It has become, thank you for your question, it has become more challenging for young companies to become public companies. And there's a number of reasons for that. I mean, partly there's increased regulation, Sarbanes-Oxley for one, Frank Dodd's the other, that makes it very expensive to be a public company, and that disproportionately burdens smaller companies. And at the same time, there's been reduced research coverage for smaller companies, and so, which is very important to encouraging trading in a public company stock. So with those factors combined, there are it's much less attractive, and there are fewer small companies going public. Ergo, M&A has become an even more important path to liquidity for risk-taking entrepreneurs.
Thank you very much. Thank you, Mr. Chairman.